Okay, we've got well on our way to 700 attendees. Good morning, everybody. I'm Rob Perry, a relationship manager with Immigration New Zealand. I hope you are all managing through these challenging times and are all safe and well. Thanks for joining the INZ webinar that will focus on the Accredited Employer Work Visa Program. The webinar will be recorded and we intend to publish. I do hope you get value from today's session. The AEWV program is a really important policy, so we thought it was very important to keep this piece of work on your radar, given all the other activity that's happening in the immigration system at the moment. Josh Kennedy, Relationship Manager for INZ, and I will take you through the presentation, and then Nick Aldos, Director Policy Integration, will join the panel. The Q&A function will be live and we will monitor it as best we can. And if we have time, we will ask the panel the questions or some of the questions that have been raised. Once again, thank you to you all for joining us today, and we will now begin the presentation. So the agenda for today is we'll talk about the changes to the temporary work visas that were announced by the government in 2019. We'll be talking about the policy decisions, the accreditation criteria, and the 3-check application process, and the planned transition from the current system to the new system. And then we'll finish up with a Q&A. Thank you, man. So, important that we do recap. It's been a while since we've communicated about this, so we thought it was appropriate to just revisit what has been on within the policy. So, in 2019, the government announced the changes to the temporary work visas. The new policy is designed to ensure that New Zealanders are first in line for jobs. The changes will increase expectations on employers to employ and train New Zealanders, make it easier for employers to recruit temporary workers for genuine shortages, and that means making the immigration system easier to navigate, improve the way we conduct immigration, education and skills and welfare systems all work together. The changes will also combat migrant exploitation and misuse of the immigration system, give migrants more certainty about the role they're applying or coming to New Zealand for, and the outcome of all of this will be that it will reduce New Zealand's reliance on lower paid temporary workers, better address our productivity, skills and infrastructure challenges, and increase the overall skill level of migrants coming to New Zealand. So, what's changing? The main changes, the new Accredited Employer Work Visa will replace 6 of the existing temporary work categories. A new employer-led application system will be introduced, and that application system has 3 checks. Employers wanting to recruit a migrant on the new Accredited Employer Work Visa will need to be accredited under the new policy. Visas that are being replaced are Talent Accredited Employer, Long-Term Skill Shortage List Work Visa, Silver Firm Job Search Visa, Silver Firm Practical Experience Visa, Essential Skills, and Essential Skills Approval in Principle. So, the 3-check system. This will simplify the visa application process and make it easier for accredited employers to fill genuine skill shortages when it is clear there is no New Zealander available to do the job or who can be trained up for the role. So there's three parts to it. The employer check, the employer must be accredited to hire a migrant. The job check, the job itself must be checked as well. This involves checking that the job pays the market rate, and in some cases, whether New Zealanders are available. And then finally, the accredited employer work visa itself. That is when the temporary migrant worker applies for the AEWV. The migrant obviously must meet INZ's health and character requirements and any skills and experience that were stipulated as part of the job check. So probably in another important aspect to this, the AEWV replaces two work to residence visas, as you know, the talent accredited employer work visa and the long-term skill shortage list work visa. These visas have closed to new first-time applications as at 31 October 2021. People who hold a work to residence visa are not disadvantaged by this closure. These individuals can continue on their pathway to residence. As a transition, work to resident or WTR visa holders who have applied for a residence from work RFW visa may find their work to resident visa is due to expire before their residence from work application has been processed. Affected migrants will be able to apply for a subsequent WTR visa after the 31st of October 2021 if they meet the requirements under the relevant visa category. So, WTR visa holders who have been unable to return to New Zealand due to the COVID pandemic border closures and have not been able to complete the required 2 years of employment in New Zealand will have the opportunity to apply for a subsequent visa if necessary and work through to residency. The talent, accredited employer and long-term skill shortage list work visa categories will remain open from 1 November 2021 for a subsequent application for people who held a talent accredited employer or long-term skill shortage list work visa and had started work in New Zealand in the role their visa was issued for before leaving New Zealand and were offshore on the 19th of March 2020 when the borders closed and returned to New Zealand after the 31st of October 2021. At this stage, there are no plans to grant a border exception to WTR visa holders who became stuck offshore due to the COVID-19 pandemic border closures. Eligible migrants will need to wait until border settings allow them to return to New Zealand before they are able to apply for a subsequent talent accredited employer or long-term skill shortage list work visa. So let's talk more about the transition plan. So the AEWV will be introduced on the 4th of July 2022. This is when people can apply for this visa. To hire a migrant on the AEWV, employers need to be accredited. To ensure employers have enough time to prepare and allow for the smooth transition, applications for employer accreditation will open on 9 May 2022. Employers do not have to be accredited until they want to start hiring migrants on the new visa. Really important to ram that home. And just to reiterate that essential skills work visa will stop on the 3rd of July 2022. So a common question that's come through, what about businesses that already employ someone on a temporary work visa? Essentially, businesses employing migrants who hold a current temporary work visa do not need to become accredited until they want to hire someone on the new visa. That question seems to come up quite often, so I hope that's as clear as we can make it. So what about businesses who employ migrants? Oh, sorry, Martin, next slide. What about businesses who employ migrants on other visas? Employers that only hire migrants on visas with open work rights, i.e. those that don't specify an employer, these people do not need to become accredited. This includes visas granted under partnership, working holiday, students with work rights. Other visa categories and schemes, including recognized seasonal employment, are not covered by this policy. Employers only need to be accredited if they want to hire people on an AEWV. I will now hand over to Josh.
Thanks, Rob, and good morning, everyone. I'm going to take you through the accreditation requirements. Some of you will be familiar with these if you attended our webinar on the 7th of May earlier this year. So what sort of accreditation an employer needs depends on how many migrants on accredited employer work visas they intend on hiring. The two accreditation levels are standard accreditation, so for employers who want to hire up to 5 migrants on accredited employer work visas at any one time, or high volume accreditation for employers wanting to hire 6 or more migrants on accredited employer work visas at any one time. So this only includes, I should reiterate, I know Rob has said it, in terms of the numbers here, only includes migrants who hold an accredited employer work visa. Migrants who hold other types of visas such as working holiday and partnership visas will not be counted towards the employer's total quota. And I guess within these two types of accreditation, employers who place migrants with third parties, who are also known as triangular employers, and those who are franchisees are required to meet additional criteria over and above that of the standard or high volume accreditation they are applying under. So let's have a look at what is needed to meet the standard accreditation requirements. So firstly, employers must show they are genuinely operating a business, including being registered as an employer with inland revenue and hold an NZBN or a New Zealand business number. Some employers may need to provide evidence showing that they are in a sound financial position, so that all the form will ask for the employer's financial position. Depending on the answers, they'll be prompted to upload evidence. So basically what a sound financial position means is the business is either profitable, it has positive cash flow, has sufficient capital, external investment or funding to sustain the business, and that includes that whether it's a subsidiary, the parent company can support it if that company is profitable, and also basically we'll consider things such as their historical trading performance pre-COVID and also any forecasted financials. Secondly, INZ must be satisfied the employer does not have a recent history of non-compliance with immigration standards. For example, employers who have been convicted of specific serious offences are permanently banned from employing migrants. For specific mid to low level immigration offences, employers will not be eligible for accreditation for certain periods. Basically, this is the employer stand down list. Once an employer has come off the stand down list, INZ can assess whether they have remedied the issues that got them on the list in the first place. INZ will also check for non-compliance of employment standards. So that's basically an employer cannot become accredited if a key person within their company is on the stand down list. And also if a key person is a banned or disqualified director in New Zealand or overseas, the employer will also not qualify for accreditation. A failed company that doesn't meet the accreditation requirements, but which re-establishes under a new name and a new NZBN to avoid accreditation being declined again, cannot be accredited. So essentially that's the issue of Phoenix companies. And lastly, the employer must take steps to minimize the risk of exploitation by allowing migrant employees to complete the 8 employment modules contained on employment.gov.nz's website. These are relatively straightforward. You can complete them in a quick and easy manner, and they are available in multiple different languages. The employer is also expected to provide migrant workers with information on their rights, and they need to also agree to pay all recruitment costs inside and outside New Zealand. So I guess these requirements are intended to ensure all employers hiring migrants meet minimum requirements to support and settle migrants and comply with immigration and employment law. As you can see from my recap just there, the evidential requirements aren't too onerous. and a lot of employers should fly through fairly easily. Where there is an agreement to commit to a certain act, such as allowing employees time to complete the modules on employment.gov.nz's website, please encourage employers to keep a record so they can demonstrate they have complied with their undertaking at the time of submitting an accreditation renewal. So moving on to high volume requirements. So in addition to meeting essentially the standard accreditation requirements, employers hiring 6 or more migrants on accredited employer work visas at any one time will also need to show a commitment to improving pay and conditions for all employees over time. So to meet this requirement, employers will need to ensure all jobs submitted at the job check either meet a minimum pay requirement of 10% above the minimum wage or are covered by a collective agreement. So 10% obviously above the current minimum wage is $22 an hour. If a high volume employer submits a job check for a job paying less than 10% above the minimum wage and it is not covered by a collective agreement, the job check will be declined. The government has previously signalled there will be a requirement to make a commitment to training and upskilling New Zealanders under the high volume accreditation requirements. So the detail of this requirement is being considered for addition to the standards at a later date after the accredited employer work visa policy is introduced. So just giving you a heads up, don't be surprised, there will be an additional criteria placed on high volume accreditation employers at a later date. So in addition to that, there will be additional requirements for franchisees. So basically they need to meet either the standard or high volume accreditation requirements depending on how many migrants they intend to employ, plus also have been operating for a minimum of for at least 12 months and have a history of hiring New Zealand workers, that being New Zealand citizens or residents. So we currently are still working through the definition of a franchisee at the moment, and we're hoping to be able to provide you with that finer detail in early 2022. So, and obviously employers who place accredited employer work visa holders with third parties will be required to meet additional standards too. So these employers are usually labour hire companies, employers who send migrant employees on secondment to a controlling third party, parent or umbrella companies who place their migrant employees with a controlling third party, such as a subsidiary company or a branch that is a separate legal entity. The migrant's direct employer must be accredited, so the direct employer here being the entity named in the employee's employment agreement, and the definition of a controlling third party is to be taken from the Employment Relations Act. So the 2 additional criteria that these triangular employers must meet to become accredited. So the third party must have a contract or other arrangement with an accredited employer under which an accredited employer work visa holder employed by the accredited employer performs work for the benefit of the third party, and the third party must exercise or be entitled to exercise control or direction over the accredited employer work visa holder that is similar or substantially similar to the control or direction that the legal employer exercises or is entitled to exercise in relation to that employee. So what if I place an accredited employer work visa holder in a different part of my business? So if you're placing an AEWV holder in a different part of your business and it is a singular entity, the employer does not need to have this controlling third party or this triangular employment accreditation. So here's an example of a company structure that would benefit from triangular accreditation. In this instance, the legal employer who the migrant has an employment agreement contract with is New Zealand Bank. Once NZ Bank is accredited as a triangular employer, they can then place the migrant with their subsidiary NZ Share Trading Co. and have them carry out work for that entity instead. So in this particular scenario, you note that NZ Share Trading Co. does not need to be accredited too. In this example here, the employer is sending the migrant to work in another branch under the same legal entity and within the same region. In this instance, the employer is not considered to be placing a migrant within a controlling third party. So therefore, your standard employer accreditation or your high volume accreditation will suffice. Right, so when it comes to triangular employers or employers placing people with a controlling third party, these employers will need to meet additional requirements in addition to the standard accreditation or high volume. These requirements are that they only place migrants on accredited employer work visas with compliant businesses, have good systems in place to monitor employment and safety conditions on site, have a history of contracting labor for the past 12 months, demonstrate that at least 15% of their workforce being placed with third parties are New Zealanders in full-time employment, so i.e. 30 hours a week or greater. And a compliant business means a business that has a New Zealand business number, is not on the stand down list for breaches of the minimum employment standards, and has declared to the employer that they do not have any immigration related issues that would prevent them from being granted accreditation in their own right. Great, so as Rob mentioned, applications will open from 9 May 2022. To apply, employers will need a New Zealand business number and to pay a fee. The system will guide you to provide all the information needed, depending on the type of accreditation you are applying for. We will retain information you previously supplied when applying for a renewal of your accreditation to obviously make it easier when it comes to renewing and less manual data input. So the initial accreditation, once approved, lasts for 12 months. At renewal, franchisees and triangular employers will be granted a further 12 months, and all other standard or high volume accredited employers will be granted 24 months at the renewal stage. To ensure employers who apply early aren't disadvantaged, an employer's accreditation will be valid for 12 months from the 4th of July 2022. So that's the day that basically this policy becomes compulsory. So for example, if accreditation is granted 20 days before the accredited employer work visa policy opens on 4 July, the total duration the accreditation will be granted for is 12 months and 20 days. So what if an employer is still accredited under the talent scheme? As you've seen, the policy requirements for the new accredited employer work visa are quite different to the previous accreditation scheme. So that means employers that are accredited under the previous system will need to apply and meet the policy requirements of the new accreditation system when they want to begin hiring migrants on the new accredited employer work visa. This means if you don't plan to start hiring migrants on the new work visa when the accredited employer comes into effect, you don't need to be accredited ahead of time. Great, so now I'm going to take you through this is the new information relating to the job check. The key job check requirements are: the employer holds accreditation and continues to meet the requirements of the accreditation. The employment offered is acceptable, so it's in line with the employment standards, pays the market rate, is at least for 30 hours per week. This is also where the high volume employers will need to demonstrate their commitment to increasing pay and conditions. High volume employers will be required to demonstrate the pay rate of the job is at least 10% above the minimum wage, or that they have a collective agreement in place for that occupation. And then obviously the employer will need to also demonstrate there are no suitable New Zealand citizens or residents available to do the works specified. This is where the different pathways come in around the job check, including the sector agreements, which are currently on hold until further notice, and the regional skills shortage lists, where only some employers will be required to do a labour market test, whereas others will be fine. So when it comes to the job check, multiple roles can be included on the same job check if the details of the job are the same, including the pay rate, occupation, minimum job requirements, and the city or region is the same. Also, the job check needs to be subject to the same labour market test conditions and covered by the same advertising and proposed employment agreement. Job checks that are approved will be valid up to 6 months, or if the employer's accreditation lapses, whatever of the two is first. So you're essentially given 6 months to go away and find a migrant and have them make their accredited employer work visa application from once the job check is approved. So a job quota is started when a job check is approved. Employers with standard accreditation can only hire up to 5 migrant workers on accredited employer work visas. A quota space is used when a job check is approved. The quota space only becomes available again if the migrant and the job has their visa expire and the migrant is granted a variation of conditions to work for another employer, or the job check expires without a visa being issued. Employers who want to hire more than 5 migrant workers on accredited employer work visas can apply for a high volume accreditation. So I guess that's one thing the employer will need to weigh up front, is whether to apply outright for high volume or apply for standard. So when it comes to labour market testing, here is what we know about who needs to do a labour market test and obtain a skills match report from MSD based on policy decisions made to date. Right now, the government is doing significant work on reconnecting New Zealand to the world. This includes considering how to align opening the border with the immigration rebalance work the Minister spoke about earlier this year. If the government makes any decisions that impact the job check or labour market test requirements, this will be communicated as soon as possible. And obviously, as at July 2021, the New Zealand median wage is $27 an hour. However, Immigration New Zealand intends to update the median wage each year. Okay, so here's a list of all the cities and regions that fit within the labour market framework. So to put this into context with the last slide, a job in Palmerston North, which falls under the Manawatu region, paying the median wage won't be required to submit any labour market testing with the job application. We are proposing to use regional and city boundaries, and this will be confirmed in, regional city council boundaries, and this will be confirmed in the instructions. Right, so when it comes to the labour market test requirements for a job paid below the median wage, so employers need to advertise a job for a minimum of 2 weeks on a national job listing website or another channel more likely to attract suitable New Zealanders, and obtain a skills match report from MSD which indicates that there are no New Zealanders available, or the employer has adequately engaged with MSD's broader program of active labour market policies, or the employer has rejected the referral of it for a limited number of specified reasons. For a skills match report to be valid, it must have been issued within 90 days of the job check application being submitted. And if there are New Zealanders available for the advertised role, employers must have an acceptable reason for declining a job seeker, which we'll cover in the next slide. So when it comes to the job advertising, as mentioned, they must be advertised for a minimum of 2 weeks on a national job listing website or another channel more likely to attract suitable New Zealanders. Under the new framework, the job advertisement must specify the minimum and maximum hourly rate or salary band, the guaranteed minimum hours of work, the minimum qualifications, work experience, and skills required, the job location, the estimated earnings where a significant portion of the pay is by piece rate or by other rates or bonuses that are not guaranteed. Also, we should probably note that jobs must be a guaranteed minimum of at least 30 hours per week, so it's nothing different to current. And bonuses or other rates which are not guaranteed will not count towards the pay rate assessment. And again, high volume accredited employers must pay at least 10% above the minimum wage, or the job must be covered by collective agreement. So if a job passes the job check, this doesn't guarantee that an employer can hire a migrant on accredited employer work visa. A migrant worker must also meet the requirements advertised. For example, obviously the appropriate experience, skills, and qualifications that the employer chose to list on the job advert. If the applicant or the migrant's evidence doesn't correspond to the minimum requirements stipulated on the previous job check or the advert, their visa application will be declined. So yeah, under the new framework, there is a list of acceptable reasons for declining a New Zealand citizen or resident job candidate referred by MSD. These acceptable reasons are insufficient relevant experience or qualification, and the requirements were included in that job advertisement. Failing a medical or drug test where this is a job requirement and is included in the job advertisement. Failing to attend a job interview without a valid reason. Undisclosed criminal convictions where disclosure of the relevant job requirement and the requirement for disclosure is included in the job advertisement. Failing a reference check. Providing false information on their CV. That the referred candidate was uncontactable, and you have tried, or the employer has used at least 2 different channels to make and made at least 3 attempts over more than 1 day to contact that person, or the candidate did not accept the offer of work. Employers cannot reject an applicant for not having their own driver's license or vehicle unless operating a vehicle is a job requirement. Employers cannot reject an MSD candidate if MSD can provide or facilitate the adequate training within 4 weeks. And employers require a skills match report from MSD to show the outcome of the engagement with MSD. So obviously there are a few new requirements under this new policy when it comes to advertising and considering New Zealand citizens or residents. So we are hoping to put out a guide in the near future for advisors and employers to follow around what advertisements need to contain to be acceptable for immigration purposes going forward. And so we'll keep you posted with that. Great. Passing it back to you, Rob, to go over the migrant check.
Thanks, Josh. So the final step in the 3-check process is the migrant check. This is where the migrant applies for the accredited employer work visa. The employer invites the migrant to apply for the visa using Immigration Online, and then INZ will then check the employer is accredited and they have a valid job check. Details of the employment must meet those approved as part of that job check. The applicant must be suitably qualified. Evidence may not be required in all cases. Applicant must meet generic health, character, and bona fide requirements intended to be the same as those that currently exist for essential skills visa. If a migrant fails any of these checks, their application will be declined. In summary, an employer-led 3-check system. Applications for employer accreditation open on the 9th of May 2022. As soon as your accreditation comes through, you can start submitting job checks. Remember, if you're advertising a role ahead of time, you'll need to meet the advertising requirements under this policy if you're wanting to later apply for a job check. The migrant check, which is when the migrant applies for the accredited employer work visa, will open to applications on the 4th of July 2022. And again, just to remind you that the last day to apply for an essential skills work visa is the 3rd of July 2022. So some stuff still to come, including tools to help with the job advertising and creating a migrant settlement pack, definition of franchisee for the purpose of franchisee accreditation, information around fees for accreditation, job check and migrant check, and the immigration instructions. So when you registered for this webinar, there were quite a few common questions that came through. So anything that Nick can add to them, but I'll be asking Nick Aldos these questions on your behalf, and he can expand on any answer that he deems appropriate, or we will just carry on with the slide detail. So thanks. Question number 1, what are the fees for each type of accreditation and each of the 3 checks, Nick, and where are we at with this?
So we need to go. Hi, everybody, by the way. We have to go through a regulatory process and get cabinet agreement to the proposed fees, and that's happening at the moment. Be aware with everything that's going on that everybody's time's sort of stretched a little bit, and so we're that work is done, but it's a matter of just getting slots for cabinet consideration. So the fees, there'll be 3 separate fees: one for accreditation, one for the job check, and one for the migrant check. And for the bulk of them, particularly for standard accreditation, fee levels are sort of around the $500 to $600, and then there's a separate fee for the job checks and the migrant check, which is the old visa application. But as I say, that works just in the process of getting agreement to the regulatory changes that are needed to put those in place, and they'll be confirmed probably early next year. I think we're looking at around February for that.
Thanks very much, Nick. Another very common question from the sector: how long will processing take for each type of accreditation and the 3-check process?
Aside from what's in there, we're setting up a new application platform as part of this work, which will be used for all visa applications, which takes advantage of the ability to automate our processes as much as possible, which will speed things up. On the accreditation side, the vast majority of accreditation applications will be in the standard column, about 80 to 90% of them. They'll be reasonably light touch and quite fast. Although, as I said, as it says there, we kind of need to get a handle on, kind of there'll be surges in volumes and that sort of thing, which will affect how long people need to wait for decisions. The decisions on both the job check and the migrant check should also both be reasonably quick, as long as the information, particularly on the job check, is all provided up front with the application, because there are smaller amounts of information needing to be assessed at each stage. Each stage should be a lot faster than the current assessment for work visas. But I'm sorry, I can't say that on average will take 2 days, because we simply don't know that at this stage. But it should be faster than the current set of arrangements.
Thanks, Nick. Something very close to the sector's heart is when will instructions be publicly available?
Yeah, so this is a similar kind of answer to the one with the fees. We're just kind of dealing with the regulatory process required to get those instructions certified, and it's likely to be around the same time as the fees come out, so it'll be in around February, so around 3 months ahead of the opening of the employee accreditation system, and 4 or 5 months ahead of when we're going live with the new work visa. So it should be plenty of time.
Yeah, that's good news. Nick, what documents and evidence will be required for each type of the accreditation and the 3 checks?
So that'll obviously vary depending on the type of accreditation required. As I say, for the vast majority of employers, we'll be going down the standard route, and the evidentiary requirements will be reasonably light, and the process can be reasonably light touch as well. So I guess at a really broad level won't be particularly onerous, although for the franchisees and some of the high volume accreditation criteria, that there will be more information required, but a lot of it will be declaration based.
Thanks, Nick. And another big one for the sector: is there a pathway to residence from this visa?
In terms of the answer that's provided there, so in some circumstances, yes, but the criteria sort of laid out there, it's 200% of the median wage, and then there's otherwise pathways to residence will need to be through the route, either another immigration category, in particular skilled migrant category, but that is also up for review in the latter half of next year, I believe.
Fantastic. A bit of commentary, obviously it's been deferred. Will the implementation timeframe be deferred again?
There's been no, well, the current dates that we're working to are 9 May and 4 July. That's what the minister's agreed to, and he's not considering a change in dates.
Excellent. And Nick, from a policy perspective, how will the AEWV prevent migrant exploitation?
So at a high level, the requirement to be accredited, will ensure that employers who have a poor record in terms of immigration requirements or employment standards won't be able to enter the system, and therefore won't be able to engage migrants through the accredited employer work visa pathway. This will provide migrants with confidence that when they're applying for their visa, that the employer is being vetted against for legal compliance, and that they've been approved to hire a migrant worker for the job that they're applying for. There's also a reduced risk of being exploited as a migrant worker, as employers will need to have no recent history of breaching immigration requirements and employment standards, and must take steps to help migrant workers settle into life in New Zealand, and must have demonstrated their understanding of New Zealand's employment laws and immigration standards. So this provides them with greater degree of certainty. It needs to be seen in the context of other work that's been going on to reduce migrant exploitation that is being run through NMB through the Labour Inspectorate in particular.
Fantastic. Thank you, Nick. Will there be access to the forms before they go live for LIAs and lawyers?
So there obviously be access to the instructions before they come into force. The accreditation and job check forms will be available from the 9th of May, which is a couple of months ahead of when the work visa goes live. And so that'll enable people to work through those requirements through that period. In addition, there's in terms of the replatforming, the new visitor visa is going on to the enhanced immigration online system from early February, and so you'll be able to go in and have a look at the system and get to grips with the look and feel and so on and so forth in terms of sort of document upload requirements. But it's certainly a substantial improvement on the current system that INZ uses.
Fantastic. And will INZ be able to process all accredited employer applications by the time the category opens in July?
So that's certainly going to be a requirement on us. So there's a couple of points to make there. One is that again, standard accreditation requirements, which will be around around 20,000 employers will need to obtain that. It's around 80% of them will be fairly light, and processing will, as far as possible, be light touch and automated. So we're confident that we won't experience backlogs. There'll be an awful lot going on in the immigration system next year with sort of reconnecting New Zealand work and the post-pandemic, or post-COVID border reopening. And so, obviously INZ has a series of challenges to work through in terms of how to do that in the most efficient and effective way. But we're relying, obviously on our systems and staff to enable that occurs as smoothly as possible. The other point to make is that and I think Rob mentioned this earlier, the requirement to be accredited will only apply to people who want to hire migrants on accredited employer work visas from July onwards. So with the 2021 residence policy, that will, obviously, people who are already in New Zealand on existing visas, on existing essential skills visas, who are switching across won't need to do this, and so there'll be large numbers of employers who have existing workforces either on temporary visas or on that new residence pathway who will not need to get accredited. It's only when they're bringing on new ones, or when they're needing to apply for accredited employer work visas that they'll need to engage with the system and get accredited. So employers will need to think that through in terms of the timing, and for a lot of them there won't be any great rush.
That's excellent. Thanks very much, Nick. Really appreciate your answers. Josh has been monitoring the live Q&A, Nick, and if you would be good enough to answer a few more questions as they've come through from the audience, we'd really appreciate it.
Okay, over to you, Josh. What have we got?
Great. Martin, feel free to stop sharing the PowerPoint. So Nick, first question that's come through is somewhat correlated. When will the streamlined essential skills visa option end? I understood our intention was to remove it at the 30th of June 2022, but
yeah, so how this will work is that the essential skills policy will essentially close at the same time that we open the accredited employer work visa. So that's right, Josh. It'll be around the end of June and the start of July. So just to be aware of that, people will be able to submit essential skills applications right up until that point.
Cool, thanks, Nick. Can you talk about, I guess, the residency pathway? So that's obviously for those who paid 200% of the median wage in more detail.
Yeah, so the details of that need to get worked through, but that'll essentially look similar to the existing residence work to residence pathways in terms of the amount of time they'll need to be on that temporary visa before being eligible for residence and need to maintain their employment status through that period. So that's reasonably straightforward. For people who don't meet that criteria, their options will sit within the skilled migrant category primarily, but any other residence category. And there's, I'm not sure, the EOIs for SMC will reopen at some point, vaguely, next year.
Thanks, Nick. And I guess, will people who are on that visa being paid 200% of the median wage, will they have the luxury of having no region-specific visa? So basically they can perform work for XYZ Limited in New Zealand?
So that'll depend on the nature of their employment and what the job check essentially allows. So if that's the nature of their employment and that's clear, then yeah, they will.
Great. Cool. Thanks, Nick. And does the company structure matter for the purposes of obtaining accreditation? So for example, can sole traders, partnerships, trusts all become accredited?
Yeah, as long as they're the key thing there is who's the employer, who's the legal employment agreement with, right? Which entity, and that is the entity at a high level that will need to obtain accreditation. So a sole trader can absolutely, become accredited, as can a legal partnership or a limited liability company, for example.
I think we probably just need to stress there that a NZBN is required. I can't quite remember if it is compulsory for sole traders at this point or not.
Will be for this, right? So if
it will be for this, yes.
Yep.
Great. I mentioned that employers will need to state the pay up front in the advertising. Can the employer put a range, Nick, as opposed to a set rate or salary?
Yeah, they can. That's no problem. Doesn't have to be fixed. It sort of acknowledges the reality in terms of that question, and that the individual, their individual applicants may vary in skills and experience, and they may need to pay more or have the opportunity to pay less, depending on the skills and experience of the person they're hiring. The median wage is obviously a key metric in terms of what that gets the migrant, and it's also likely to be linked to things like the visa duration, and also potentially what labour market checking is required.
Thanks, Nick. I know you don't directly work in the operations part of the business, but are you able to potentially shed some light on INZ's plan of attack in terms of resourcing and processing of all these standard accreditations? And if our goal was to have all the ones submitted between 9 May completed by the 4th of July when the policy becomes compulsory and live?
Certainly operationally, when we're very keen to prevent queues building up. Obviously, if we get an employer accreditation application on the 2nd of July, we can't commit to having that finished by the 4th. But certainly, we're looking to stay in flow as much as possible, and obviously doing workforce planning at the moment in terms of how many staff we're going to need working on these, where they're going to be, and kind of what the service standards are going to be.
Thanks, Nick. And when it comes to the triangular or the controlling third party accreditation, where the employer can obviously send the migrant around different entities, are they able to send the migrant to an entity outside of, for example, the direct employer is in Auckland and they're wanting to send the migrant to an entity in Wellington? I would assume it all depends on the migrant's visa label.
Yeah, that's true. So the main thing is being, kind of as much transparency as possible in terms of what the role is and where and for whom they're going to be working, so that when the granting of the visa is sufficiently flexible. So that kind of happens at the moment, right? Where you need to, if the role's in multiple regions, that needs to be set out as far as possible on the visa conditions.
Yeah, and obviously, just to probably confirm too, you need to see when you're sending the migrant to another entity, obviously they need to perform work in line with the occupation stated on their visa. It's not you can just send them to go work and do any work for another person or for another company. Thanks, Nick. Good question here. So I mentioned about those who are placing migrants with controlling third parties. How would the home employer or the substantive employer monitor the health and safety of the third party?
So that's just be a matter of understanding who they're being placed with, and regularly seeking feedback from the employee about any concerns or issues. So that'll be reasonably light touch, but that's just the obligations on the primary employer to maintain, to ensure themselves that they're sending their employee into a safe environment, and to take steps to document what they've done in that regard.
It's safe to say, Nick, I guess the employer isn't required to perform an assessment as such, but they're expected to at least ask and exercise their judgment on whether the third party's systems and processes are adequate.
Yeah, that's correct.
Great. So we've got a question about the job check around. So I mentioned that the employer must stipulate upfront the minimum experience or qualification requirements required. So if a migrant presents, or if a job check is subsequently approved and a migrant makes an application and does not have the minimum experience and or qualification requirements, is there any wiggle room?
There's always wiggle room, but broadly speaking, policy is that the job check's been approved for a specific role requiring those skills, those skills, qualifications, and experience. The migrant doesn't have it, that would on the face of it be a decline.
Great. And question been asked: how do LIAs fit into the process? Are they able to represent and submit the employer accreditation? Are they able to also represent on behalf of the job check and obviously the migrant check?
Yeah, absolutely. Yep.
Nice and simple. I'm just seeing if there's any other ones that have been frequently upvoted. We're getting this question here about whether, obviously we're working closely with MSD around these new job check requirements. Are they being additionally resourced or is there? Do you know if there's any conversations with MSD going on about making sure that they're up to play and able to handle these new job checks?
Yeah, so we've worked really closely with MSD in terms of how the system and our how INZ and MSD interact to ensure that the system's kind of understood and the processes are understood. They're putting in place new systems to enable the automatic flow of information between INZ and MSD, just to make sure that as far as possible, that's streamlined and efficient. Yeah, absolutely, there's been joint project with us and MSD in that regard, so that we're all on the same page and all our systems are able to talk to each other, efficiently and effectively.
Nick, for accredited labour hire employers whose accreditation is expiring in April 2022, what will happen to them between April and July 2022? Can they still support migrant work visas for 3 years as per WK 4.1 between that period?
I think so, I'm not sure. Josh, do you know off the top of your head?
I think the answer is yes.
Great, thank you.
Great. And just I see it's coming through the chat. Can people obtain a copy of the PowerPoint and or the recording? So as Rob mentioned at the start, the intention is to make the recording available subject to no production issues. And don't see why not around providing a PDF copy of the PowerPoint, similar to what we did with the 2021 resident visa webinar. That's really it from the Q&A, Rob. So over to you.
Okay. Well, obviously, we hope that today's webinar has been useful to you all. It looks like we had close to 1,000 attendees, so that's good. All the information that we talked about today is on the website, and obviously with such a big policy, there will be future communications which may include further webinars. I think, not 100% sure, but I think this is the last webinar that we intend to host for 2021. 2021 has been an incredible and challenging year for each and every one of you, and INZ are no different. On behalf of Josh, Nick, and myself, we would like to wish you and your families a safe, happy and relaxing Christmas and New Year, and we wish each of you a prosperous and happy 2022. Thank you very much indeed for attending today, and look after yourselves, and thanks again for attending.